Hello everyone, my name is Asmita Singh and today I am presenting on section 144 of IPC. But before coming to section 144, let me explain the three categories of sections in IPC. The first category deals with the offences, means in this category only offence is described in this section. The second category deals with the punishment, which means that in this section punishments are described for the offences, and the third category of the sections are those sections which deals with the offences and the punishment. Now comes the main discussion, that is section 144 of IPC. Section 144 is mentioned in chapter 8 of IPC, that is of offences against the state tranquility. This chapter, that is chapter 8, consists of 22 sections commencing from section 141 to 160, including 153A and 153B, dealing with a class of offences falling between offences against the state on the one hand and the offences against the person and property on other hand. The offences discussed in this chapter are commonly known as group offences. Now comes, what is unlawful assembly? Unlawful assembly is described in section 141, 142 and 143. And joining unlawful assembly with armed forces, that is deadly weapon, is described in section 144. Section 145 deals with joining or continuing in an unlawful assembly knowing it has been commanded to disperse. The fourth part is, that is section 150, hiring of person to join in unlawful assembly. Section 157, harboring person hired for unlawful assembly, and 158 talks about being hired to take part in an unlawful assembly. Rioting is mentioned in section 146 and 147. Rioting with deadly weapon is mentioned in section 148. Assaulting or obstructing a public servant in suppression of a riot is mentioned in section 152. Wantonly giving provocation with intent to cause riot is mentioned in section 153. Section 154 talks about liability of the owner or the occupier of a land on which an unlawful assembly is held or riot is committed. 155 talks about liability of the person for whose benefit a riot is committed, and 156 talks about liability of the agent of the owner or occupier for whose benefit a riot is committed. Section 153A talks about promoting enmity between different classes, and after is mentioned in section 159 and 160. But our main discussion is on unlawful assembly. So let us talk about section which deals with unlawful assembly. As we know that an assembly of 5 or more persons is designated as an unlawful assembly if the following points, 5 points which are given below, is the common object of the person. First one is to overthrow by criminal force or show of criminal force the central or any state government or parliament or the legislature of any state or any public servant in the exercise of lawful power of such public servant. The second one is to resist the execution of any law or any legal process. The third one is to commit any mischief or criminal trespass or other offense. The fourth one is by means of criminal force or show of criminal force to any person to take or to obtain possession of any property, and so on, which are mentioned below. The fifth point is by means of criminal force or to show of criminal force to compel any person to do what he is not legally bound to do or to omit to do what he is legally entitled to do. The explanation of this is an assembly which is not an unlawful assembly when it assembled may subsequently become an unlawful assembly. Now comes the section 142, being a member of unlawful assembly. Whoever, being aware of the fact which render any assembly an unlawful assembly, intentionally joins assembly or continues in it, it is said to be a member of an unlawful assembly. And section 143 talks about the punishment. If whoever is a member of an unlawful assembly shall be punished with the imprisonment of either description for a term which may extend to 6 months, or fine, or with both. Now moving further, we should know what are the essentials of unlawful assembly. To constitute an unlawful assembly, the following three conditions must coexist. The first one is thus there must be an assembly of 5 persons. The second one is the assembly must have a common object, and the third one is the object must be to commit one of the 5 illegal objects which was mentioned in section 141. Now, the second thing is that which is important to constitute an unlawful assembly is assembly must be of 5 persons, which I have told you earlier. An assembly of 5 persons or more than 5 persons combined for one or other purpose indicated in section 141 is declared in a law an unlawful assembly, and fixing the number of an unlawful assembly at 5, section 141 IPC has made a departure from the English law. Means in English law, to constitute an assembly as an unlawful assembly, we need only 3 people, whereas in India, we need 5 people to constitute an assembly as an unlawful assembly. In R versus Hunt, English law has described what is an unlawful assembly. An assembly of 3 or more persons with intent either to commit a crime by open force or to carry out any common person, lawful or unlawful, in such a manner as to give firm and courageous person in the neighborhood of the assembly reasonable grounds to apprehend a breach of peace in the consequence. Assembly must have common objects. It is given below. The law does not declare a mere assemblage of men, however large, illegal unless it is inspired by an illegal object. And it means that an assembly cannot be an unlawful until and unless it is inspired by an illegal object. The mere presence of a person at the scene of the offense or in the crowd does not make him a member of an unlawful assembly, unless it is proved that he did something or omitted to do something which would make him a member of an unlawful assembly. In other words, it must be proved that the person had a common object and they were acquitted by common object, and that the object was one of the set out in section 141 of IPC. The next ingredient is mere presence in assembly is not sufficient. The Supreme Court has more than once said or reiterated the rule that mere presence of a person at a place where members of an unlawful assembly have gathered for carrying out their illegal object does not incriminate him as a member thereof, unless it is shown that he did something or omitted to do something which would make him a member of an unlawful assembly, or unless the case falls under section 142 of an Indian Penal Code. Next ingredient is illegal objects. An assembly of 5 or more persons is designated as an unlawful assembly if the common object of the person composing that assembly is any one of the following 5 objects declared illegal under section 141 IPC, that is, to overthrow government by criminal force, or to resist the execution of law or illegal process, or to commit an offense, forcible possession or disposition of any property. Fifth one is to compel any person to do illegal act. Now comes section 144, that is joining unlawful assembly armed with deadly weapon. Whoever being armed with any deadly weapon or with anything which used as a weapon of offense is likely to cause death is a member of an unlawful assembly shall be punished with the imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Here the 3 things are mentioned: 2 years offense, or with fine, or with both. It means that he can be punished with the imprisonment of 2 years, or with the fine, or he can be punished with the imprisonment and fine. So let us talk about the classification of offense under section 144. The punishment is for 6 months, or fine, or both. It is a cognizable, bailable and triable by any magistrate, and it is non-compoundable. Unlawful assembly. The offence under section 144 is aggravated form of the offence prescribed in 143. In 143, it was not talking about the deadly weapon, but in 144, the punishments are given for unlawful assembly armed with the deadly weapon. The risk of the public tranquility is aggravated by the intention of using force, evinced by carrying arms or deadly weapons such as pistol, guns, swords, etc. Section 144 provides that where a member of unlawful assembly is armed with deadly weapon, which used as a weapon of offence is likely to cause death, he would be liable to enhanced punishment which may extend to 2 years of imprisonment or with fine or with both. Now comes section 145. Joining or continuing in unlawful assembly knowing it has been commanded to disperse. Here the person knows that the assembly has been said to disperse, but knowingly a person joins the unlawful assembly. Whoever joins or continues in unlawful assembly knowing that such unlawful assembly has been commanded in a manner prescribed by law to disperse shall be punished with the imprisonment of either this description for a term which may extend to 2 years or with fine or with both. Now comes section 150. The sections which I am telling you is all about unlawful assembly. It's not about affray and all. Now section 150. Hiring or convening at hiring of person to join unlawful assembly. Whoever hires or engages or employs or promotes or conveys at the hiring, engagement or employment of any person to join or become a member of any unlawful assembly shall be punished as a member of such unlawful assembly, and for any offence which may be committed by any such person as a member of such unlawful assembly in pursuance of such hiring, engagement or employment in the same manner as if he had a member of such unlawful assembly or himself had committed such offence. Here in section 150, the person who is hiring someone else to commit an unlawful assembly or to join unlawful assembly, he will be punished in a same manner as if he had been a member of such unlawful assembly or himself had committed such offence. Section 157 talks about harboring person hired for an unlawful assembly. Whoever harbors, receives or assembles in any house or premises in his occupation or charge or under his control any person knowing that such person have been hired, engaged or employed or are about to be hired, engaged or employed to join or become member of an unlawful assembly shall be punished with the imprisonment of either description for a month, which may extend to 6 months or with fine or with both. It is very simple. Now comes section 158. Being hired to take part in an unlawful assembly. Alright, whoever is engaged or hired or offers or attempts to be hired means here the person who is being hired, suppose A is a person, okay, who has hired B. So here in 158 B will be punished. Not here the A will also be punished, but in this section B will be punished. So whoever is engaged or hired or offers or attempting to be hired or engaged to do or assist in doing any of the acts specified in section 141 shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both, or to go armed, and whoever being so engaged or hired as aforesaid goes armed or engages or offers to go armed with any deadly weapon or with anything which used as a weapon of offence is likely to cause death shall be punished with the imprisonment of either description for a term which may extend to 2 years or with fine or with both. So it was all about section 144, 141, 142, 143, 145, 150, 157 and 158. Thank you.